as a small startup has identified another company, large or small, that are potentially infringing on their patents, where's the starting point for them at that point?
So if a company is identified as potentially infringing a patent, the first step is always to, with the assistance of a patent lawyer, to consider whether those acts do fall within the scope of the patent. And that involves not only looking at the scope of the claim and considering the doctrine of equivalence, which is a principle which applies in some European countries, including the UK now, which potentially broadens out the scope of patent protection, but also to look at where the potential infringing acts may be taking place. So quite often they may not be in one country. It's possible that manufacture may take place in one country. There could be stockpiling or warehousing in another country. The product may move through several other European countries.
Yep.
So there is a tactical element to assessing where is the best country in which to bring that first claim for patent infringement. It's also worth considering with either a patent attorney or a lawyer the validity of your own patents. Although they have obviously been granted by the European Patent Office or a national patent office, they go through what I would describe as a relatively coarse filter in that examination process. And it is important that before any patents are asserted, that the company is satisfied that those patents are as watertight in terms of validity as they can be.
So that'll be the worst case scenario, which is you're challenging someone else for encroaching on your IP.
Yes.
And then them turning over your patent and invalidating it.
Indeed, indeed. So a dispute starts as against one company, and then that one company is able to essentially revoke the patent owners, potentially their crown jewels, and then that removes the monopoly right as against all parties.
So it sounds like before pursuing any litigation, it is checking the merits of the other parties' infringement on your own patents.
Yep.
It's checking that your patents are watertight.
Yep.
And then also thinking quite carefully about the territory which you're going to initiate the litigation in.
Certainly. And in addition to that, I would also say it's important to consider what it is as the patent owner you are wanting to get out of this.
Right.
Are you wanting to get an injunction? So what would be the satisfactory commercial outcome? Would it be for the competitor to stop all manufacture? Or would it be acceptable from a commercial perspective if they were to continue doing their acts but pay a royalty of X%? And the answer to that always depends on the circumstances and what the particular business considerations are. But as a patent owner, that is one of the great advantages of having patent protection is that it does confer on the patent owner that exclusive right to make, use, keep, import and so forth, the product or the process, to the exclusion of third parties.
Right.
So if in principle, if a patent owner wants an injunction, then it can get one. So it's quite a powerful negotiating tool.